Welcome back to Court TV Live. I'm Julia Janae. After an emotional first day of testimony yesterday,
I'm not alleged. I did it. 6 words, spoken out loud, captured on a police body camera, in front of a uniformed officer, seconds after a 17-year-old boy was still receiving chest compressions on the grass of a Texas track field. That is where we are going. But to understand why those 6 words matter so much, why they may be the single most devastating piece of evidence in this entire trial, we need to go back to the beginning. To a high school track meet in McKinney, Texas. To a 5-inch folding blade. And to a teenager who, when given the chance to say absolutely nothing, chose instead to say everything. My name is not important. What is important is this. By the time this video ends, you will understand exactly why spontaneous statements made in the moments after a crime are considered some of the most powerful evidence in American courtrooms, and why a defense attorney's worst nightmare is a body camera that was already rolling. Let's go. The Collin County Courthouse in McKinney, Texas, sits in one of the fastest-growing suburbs in the country, a place that, until recently, most people outside the state had never heard of. Day 2 of the murder trial of Carmelo Anthony.
From the jury box, those jurors returned to the courthouse in McKinney, Texas today for more testimony in the track meet stabbing trial of Carmelo Anthony. Thanks so much for being with us as we follow day 2 today. We understand that the court is breaking for their lunch. That happened a short time ago. That means our eyes and ears in the courtroom. Cody Thomas, he is going to be able at some point to be able to join us from outside of the courthouse, but he's been keeping us up.
Not the NBA player. A different young man entirely, began the way the first day apparently ended, with tears, with grief, with the particular kind of silence that falls over a room full of people who have seen something they cannot unsee. The 12 jurors who filed back into that courtroom on day 2 were not lawyers. They were not judges. They were ordinary people from Collin County who had already, by day 1's end, reportedly been seen wiping their eyes in the jury box. That detail matters. We will come back to it. On trial is Carmelo Anthony, a teenager charged in connection with the fatal stabbing of Austin Metcalf, 17 years old, at a track meet. A sporting event. The kind of afternoon that is supposed to be unremarkable. The kind of afternoon that parents attend without a second thought. Austin Metcalf did not survive it.
It's the first witness on the stand, 3 witnesses so far, first responder and 2 officers. The first responder was a firefighter and paramedic that pretty much testified to the severity of the wounds once he arrived to Austin Metcalf's body, and just talked about the intense life-saving efforts they went through trying to revive him, to which, of course, to no avail. But they talked about, attaching a machine to his chest to read a pulse, and he had no pulse. They said it was flatline. There was an acronym he used, a medical term, and the prosecutor asked for, simplicity for the lay people in the gallery, and he just said, yeah, he had no pulse. He was pretty much dead in a cardiac sense. They loaded him up into the back of the ambulance, to which, he eventually did not regain consciousness. But then we went on to see more from officers, and they were testifying about their response to.
The prosecution's theory, as it has emerged across 2 days of testimony, is straightforward. Carmelo Anthony brought a knife to that track meet, used it with lethal intent, and then, in the moments after, made statements that undermine any claim of self-defense. The defense's theory is equally clear. This was not murder. This was a young man in fear for his life who acted to protect himself. What the body cameras captured that afternoon is, depending on which side you believe, either the prosecution's most powerful weapon or context that has been stripped of its full meaning. You are going to decide which one it is. The first witness of day 2 was a firefighter and paramedic, a first responder who arrived at the scene while Austin Metcalf was still on the ground. This witness did not testify about who did what or why. His testimony was about something more basic, more brutal. He testified to the wounds. He testified to the life-saving efforts, the machine attached to Austin's chest, the readings, the flatline. The medical acronym he used that the prosecutor, in a moment that is worth noting, asked him to translate for the jury. For the lay people in the room, he said. Just tell them in plain English. The paramedic obliged. In plain English, he told the jury Austin Metcalf had no pulse when he arrived. He was, in a cardiac sense, already dead. They loaded him into the ambulance anyway. They kept working. He did not regain consciousness. That testimony is not legally complicated. It is not procedurally interesting, but it is emotionally foundational. It is the prosecution establishing, through the most credible kind of witness available, exactly what the result of this case was before a single question of guilt or innocence has been answered. The jury needed to sit with that, and they did. Then the officers took the stand. The school resource officer, identified in reporting from inside the courtroom as Eduardo Cortez, was among the most significant witnesses of the day. A school resource officer, for those unfamiliar, is a law enforcement officer assigned specifically to a school campus.
He described the arrest of Carmelo Anthony. He said an adult pointed out the suspect and said, "That's the guy." I called him towards me. I patted him down. I had him raise his arms and ordered him to walk with me along that fence line. He obeyed me. He didn't try to run away. I turned on my body-worn camera, had him place his hands behind his back, and had him detained. The thing that most shocked me was that a student brought a knife to a track meet. And this witness agrees that that alone was unprecedented. Then on cross-examination, this witness...
Kids streaming toward him, pointing. Someone's been stabbed. They pointed in Carmelo's direction. He approached the young man. He described what came next in terms that, from the outside, sound almost quiet. Carmelo obeyed. He raised his arms. He walked alongside the fence line as instructed. He placed his hands behind his back. He did not run.
Commotion when he ran out there to the scene, all the kids running to him saying, "Someone's been stabbed," and they pointed towards Carmelo's direction. And so you see on the body cam when he finally approaches Carmelo, and Carmelo seemed to cooperate. He was being very cooperative. He was being compliant. He didn't try to run away. But the key thing about this testimony here on the body cam, you hear Carmelo say to the officer, "He put his hands on me. I told him not to." And when he says that phrase, he clearly he's crying hysterically. You can hear him sobbing in a very emotional state. But the prosecution's harping on that last half of that statement, the "I told him not to" part, because the prosecution says that's simply a lie. We know we've heard that phrasing, he told him not to put his hands on me, or "put your hands on me and see what happens." That's the narrative that the prosecution's running with, and that eventually led.
That compliance matters to the defense. It is being used, and will likely continue to be used, to paint a picture of a young man who was not acting like someone who had just committed a murder, who was scared, yes, who was crying, yes, but who cooperated, who didn't flee. But here is where the body camera changes the texture of that cooperation. On the footage, you can hear Carmelo crying, sobbing, audibly distressed. And in that state, he says something. He tells the officer, "He put his hands on me. I told him not to." The prosecution's position is that this is not just a statement of distress. It is a reference to the confrontation. The moment, the prosecution argues, when Carmelo warned Austin Metcalf not to touch him, and then followed through on that warning with the knife. The prosecution contends this is not a frightened teenager describing what happened to him. It is a frightened teenager describing what he did. And if that interpretation is correct, then that spontaneous statement is not evidence of innocence. It is something considerably more complicated. But the 6 words that matter most come from a different moment on a different officer's body camera. Here is what you need to understand about spontaneous statements, because this is the legal concept at the heart of what Day 2 revealed. In courtrooms across this country, there is a category of statement called an excited utterance. The technical definition varies slightly by jurisdiction, but the principle is universal. When a person makes a statement in the immediate aftermath of a startling event, while they are still under the stress and excitement of that event, before they have had time to think, to calculate, to consult a lawyer,
to construct a narrative, that statement is treated as particularly reliable, particularly honest. Courts allow these statements into evidence precisely because they are considered the closest thing we have to an unguarded window into what a person actually experienced and actually did. Body cameras have made excited utterances more powerful than ever before. Not because they create them. Human beings have been making them for as long as there have been traumatic events. But because now they are captured, time-stamped, unedited. There is no dispute about what was said. The only dispute is what it means. On a second officer's body camera, played inside that McKinney courtroom with a jury watching, you can hear a moment that the prosecution clearly intends to be a turning point. An officer refers to Carmelo as the alleged suspect, and Carmelo responds out loud for the camera to capture. "I'm not alleged. I did it."
Austin Metcalf. But there was another officer whose body cam was played during this officer's testimony where you heard the officer say, "We have the alleged suspect," and then you clearly hear Carmelo say out loud, "I'm not alleged, I did it." So kind of damaging to the defense's case here. But then we just heard from an officer who arrived who did not partake in any life.
Think about what that moment contains. A teenager in shock, a teenager who is crying, a teenager who at this precise second had no attorney beside him, no one coaching him, no one telling him what to say. And what he chose, without coaching, without counsel, without time to think, was to correct the record. Not to deny, not to invoke his rights, not to say nothing, to correct the word alleged. That is a spontaneous statement. That is an excited utterance.
Mr. Anthony in the moment of the event while it's still on his mind and heavy on his heart. So oftentimes these body-worn cameras, which capture the aftermath of the incident, are best evidence because they capture things that are said and things that are done before anybody has time to consult with an attorney and develop a defense to what the particular charges are.
Al, what do you think about the weight of that body camera? Because I do want to add some of the notes that we're getting from the courtroom that you can hear on it a handful of crimes.
And that is exactly why legal commentators watching this testimony called it plainly damaging to the defense. Now, stop here for a moment, because I want to ask you something directly. We are watching a case where a teenager is dead and another teenager is on trial. The knife that killed Austin Metcalf was 5 inches long. It was a folding blade, the kind that springs open with the stroke of a thumb, one-handed, fast. The prosecution demonstrated this for the jury in open court.
Knife, which a lot of people keep with them, that has a little blade, a bottle opener, things like that. So the big question is, what was this young man doing at this track event with this type of knife that it seems like he brought it maybe for his particular purpose? So that's the big question as to what he was doing with this type of knife, which is not what we usually see people walk around with on a daily basis.
Yeah, we keep hearing that question. Why did he have the knife? Now, there was something that came out today, Al, where on cross-examination.
Using the actual weapon. The jury saw it for the first time that day. They watched the blade swing out. They watched how quickly it opened.
And they did a demonstrative effort in front of this jury where they showed that the blade could be swung out really quick with just the stroke of a thumb. You could open it really quickly with one hand, but the impactful part of that testimony is that we saw the body cam from this officer where you actually see Austin Metcalf's pretty much lifeless body, everyone trying to give him chest compressions, but you see the body on screen, and that obviously brought out a visceral, emotional reaction from the Metcalf family. Plenty of tears and sobbing and consoling. And I looked.
The school resource officer, the law enforcement officer whose job it was to keep students safe at exactly this kind of event, testified that in his experience, a student bringing a knife like this to a track meet was unprecedented. That was his word, unprecedented. Here is what I want you to think about. We know, because cross-examination confirmed it, that possessing a knife under 5 inches in Texas is not a crime.
Zero tolerance for having a pretend gun. You can't even bring a water pistol in some instances if it looks like a real weapon. So that is a zero tolerance policy. Okay, having the possession of the knife is not a criminal offense in and of itself. That's correct. Okay. But it's a school event. He's a student. He's there. He's got a knife, 5-inch switchblade.
It is legal to carry. The defense made sure that came out, and they were right to do so. That is a fact, and facts matter. But here is the other fact sitting right next to it. Legal to possess does not mean appropriate to bring.
Spells any, false rumors that it was a stake or something that was used for the sporting event that was going on. This is a knife. This is a knife that is a dangerous knife. And this is a knife that should not have been at a sporting event for a high school team. Perfect. Right there.
Gray, weigh in as well about that knife. What did you think about hearing that it's a 5-inch blade, that it was folded out?
That's my best friend. That's my brother. While trying to get to Carmelo. It captured, from a separate angle, the sight of Austin Metcalf on the ground, with people trying to save him. Chest compressions, uniformed hands pressing down. And that footage reportedly brought audible sobbing from the Metcalf family inside the courtroom. The jury saw all of it. They saw the knife. They saw the body cam. They heard the children. They heard the statement. Now here is the question that the prosecution is planting in that jury's mind, and it is a devastatingly simple question. In all of that footage, in all of those spontaneous moments, in all of those excited utterances captured on camera before anyone had time to build a defense, what did Carmelo Anthony not say? He did not say they were going to kill me. He did not say I was afraid for my life. He did not say I had no choice. He did not say I had to do it or they were going to beat me. He did not say I was defending myself. None of it. Not once. That silence is not nothing. That silence is the self-defense argument breathing its last.
I had to do this to be able to get out of there because they were going to take my life. They were going to kill me. They were going to beat me to a pulp. I didn't hear any of that. So the self-defense argument starts to kind of fade a little because that's at the moment when he's confronted by this officer and has the chance to say, listen, I did this because I had to. If I didn't, I would not have been able to get out of that tent. They were trying to beat me up. They were trying to do something to me. They were trying to kill me. You don't hear that. So
self-defense, in its simplest legal form, requires a reasonable belief of imminent harm. That is the standard everywhere. In Texas, the law gives defendants significant latitude under what is sometimes called the Castle Doctrine, the right to defend yourself with force when you reasonably believe you are in danger of serious bodily injury or death. That latitude is real. The defense will lean on it. But here is what experienced trial attorneys will tell you. The best evidence of whether someone acted in genuine self-defense is almost always what they say right after it happens, not what their lawyer argues 6 months later. Not what they tell their family. What comes out of their mouth in the first 60 seconds, before calculation, before fear of consequences, before they understand what is happening to them legally. When Officer Cortez approached Carmelo on that fence line, Carmelo was crying. He was emotional. He was, by every account, in distress. That is the moment, the exact moment, when a person who genuinely acted in self-defense would be most likely to say exactly that. Because in genuine self-defense, the fear does not disappear the instant the threat is gone. It spills out. It explains itself. It is the first thing out of your mouth because it is the only thing in your mind. What came out instead was, he put his hands on me. I told him not to. And then to a different officer on a different camera, I'm not alleged. I did it. No fear, no claim of necessity, no framing of what happened as something that was done to him.
2 statements, 6 words, and a self-defense argument that, as one legal commentator put it, starts to deflate. The emotional weight of this trial is not abstract. It is not theoretical. It is 2 families in a courtroom in McKinney, Texas. One of them is watching footage of their child receiving chest compressions on a grass field. One of them is watching their child stand trial for murder. Both of them are living inside a tragedy that no verdict will fully resolve. The jury watched the Metcalf family weep.
Towards Carmelo Anthony's side, and it was pretty stoic. There was a lack of emotion there, not necessarily in a negative sense, but just really take evidence here, all the facts of this case as the prosecution presents it thus far. That's the latest right now. I'll send it back to you.
Car, thanks to Cody Thomas for that report there in McKinney, Texas. Let's bring in our guests who are standing.
Reporters in the room noted that the Anthony side was, by contrast, stoic, present, attentive, absorbing the evidence, but not visibly breaking down. That observation was made without judgment by the journalist who logged it, and that is the right way to receive it. Grief does not have a dress code. Composure in a courtroom is not evidence of guilt, any more than tears are evidence of innocence. But the jury saw both, and juries are human. What happens next in this trial is still unwritten. We are 2 days in. The defense has not yet presented its case. Carmelo Anthony has not testified. We do not yet know what the defense will argue about the confrontation, about what Austin Metcalf did in the moments before the knife came out, about what Carmelo believed was about to happen to him. None of that has been heard yet. And that matters. It matters enormously. So here is what day 2 actually gave us, stripped of everything else. The prosecution built a wall, brick by brick. A paramedic who described a flatline, a school resource officer who called the knife unprecedented and confirmed the arrest was calm, a second officer whose body camera captured a 5-inch blade being demonstrated for a jury for the first time. And underneath all of it, 2 statements, 2 uncoached, unfiltered, excited utterances from a teenager who did not yet know he needed to stay silent, that the prosecution will argue tell the jury everything they need to know. I'm not alleged. I did it. Here is the lesson from today that goes beyond this case. If you ever find yourself in a moment of crisis, a car accident, a confrontation, an incident that may later be examined by a court, understand this. Everything you say in those first moments is being captured. Everything you do not say is also being captured. Body cameras are not just surveillance. They are time machines. They bring the jury back to the exact moment before anyone had a story, before anyone had a lawyer, before anyone had decided what the truth was going to be. That is why prosecutors love them. That is why defense attorneys fear them. Spontaneous statements are the most honest things most people will ever say in their lives.
Today, that is always really important for jurors to see as much as they can. And here, they get to see the body camera not of days later when police catch someone, but right after it happens, this school resource officer is on the scene.
Right, and the body-worn camera presumably captures some spontaneous statements, excited utterances made by...
Because they are said before the person saying them understands the stakes. And sometimes, in a courtroom in McKinney, Texas, in front of 12 jurors who are already wiping tears from their eyes, the most honest thing a person has ever said is also the most damaging thing they have ever said. The trial continues.